Start. Feeling aggrieved by the order of discharge dated 31/5/2022, the petitioner preferred original application number 649 of 2022, full stop. The tribunal, after appreciating the fact that the petitioner had submitted his willingness for extension on 29/7/2020 and the revised policy dated 5/5/2020 came into existence with effect from 1/6/2020, had returned a finding that the case of the petitioner for grant of extension could not be considered in accordance with old policy as the applicant submitted his willingness for extension only on 29/7/2020, by which time the new policy was in force, full stop. The learned tribunal also gave a passing reference, inasmuch as it observed that had the old policy been in force, the applicant would have been benefited for service extension of 11 months, as by that time he would have attained the age limit of 54 years, full stop. In this backdrop, the learned tribunal has dismissed the original application void judgment/order dated 29/3/2023, full stop. It is this judgment/order dated 29/3/2023, which has been challenged in the instant writ petition, full stop. Learned counsel representing the petitioner drawing our attention to reasoning given by the learned tribunal while dismissing the original application, has submitted that the learned tribunal has not appropriately considered the issues involved in this matter, inasmuch as the petitioner was promoted to the rank of Subedar Major with effect from 1/4/2020, and at that relevant time, the petitioner was governed by the procedure and guidelines enumerated in the letter of integrated headquarters of Ministry of Defense, Army 29/2010, from which willing for 2 years extension in age/service is deemed unless the officer may submit his unwillingness certificate 2 years before his retirement date, duly countersigned by authority concerned, full stop. Learned counsel has submitted that admittedly, the petitioner was promoted to the rank of Subedar Major on 1/4/2020, that is during the lockdown period, with effect from 25/3/2020 to 31/5/2020, and at that relevant time, the petitioner was not screened due to complete lockdown under old policy, that is dated 29/2010, full stop. In the meanwhile, the amended policy dated 5/5/2020 came into existence, by which the individual who have been under the permanent low medical category prior to commencement of extension would be discharged on completion of normal terms of engagement without extension, which was not available in the old policy, full stop. Submission of the learned counsel, therefore, is that once the promotion of the petitioner to the rank of Subedar Major was made with effect from 1/4/2020, and the petitioner's case is covered under policy dated 29/2010, therefore, the amended policy dated 5/5/2020, which was applicable with effect from 1/6/2020, would not be made applicable in the case of petitioner, full stop. However, while considering the claim of the petitioner for extension of service, the respondents have erroneously applied the amended policy 5/5/2020 and declined the claim of the petitioner for extension of service, which according to him, is per se illegal and arbitrary, full stop. In this backdrop, learned counsel submits that the learned tribunal has erroneously returned a finding that the petitioner's case for grant of extension could not be considered in accordance with old policy, full stop.